so we're up here.
Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before the court will draw near and give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, that was our marshal, Charlie Crawford. Thank you. As Charlie indicated, I am Judge Lambert. I will be presiding this morning over the oral argument. Welcome to the 5th District Court of Appeal here today. We have 3 cases on our docket. Before I get started, let me introduce the panel that will be presiding before you. To my right and to your left is Senior Judge Bruce Jacobus. Judge Jacobus was a judge on our court for about 5 or 6 years ago, back in the 1940s. We're very happy to see he's still around and able to help us today. And to my left, to your right, we're pleased to have Judge Heather Higbee. She is from Orange County, right? She's an associate judge sitting for Judge Grosshans today. She's also interviewing for we have an open spot. Judge Berger, you might recall, was recently anointed to the federal court, Middle District, so we have some big shoes to fill. Wendy had some big feet. So Judge Higbee is applying for that job, and we wish her well in her interview. I believe it's tomorrow. Okay. Each side will have 20 minutes. I will have the 5-minute default time for the rebuttal. If you, as the appellant, would like some different amount of time, just tell me when you're up here and I'll adjust the clock accordingly. If anybody has any cell phones or other electronic devices, please place them in either turn them off or in the silent mode so that we can avoid any of them going off and that you distract the attorneys during their respective arguments. That being said, our first case is case number 18-3213, DUANE Michael. One other thing, after our second case, we're going to take a break and we'll have coffee in the attorney's lounge here, just off to the right when you go out. If you want to join us, we'll take a few minutes and socialize before we come back for the final case, or not. You don't have to. But all right, so we'll start with the first case, 18-3213, DUANE Michael. Is it COTTIER?
I believe it's COTTIER, Your Honor.
COTTIER versus State of Florida. So, counsel, whenever you're ready.
May it please the court, opposing counsel. My name is Sean Gravel. I represent Mr. COTTIER, and I will use the default 5 minutes of rebuttal, Your Honor.
All right, go ahead.
And the main issue I'd like to focus on today is the second issue of my brief, which is the jury instruction. There is no standard jury instruction for the charge of misapplication of construction funds. As a result, both attorneys at trial had to write their own jury instructions, but they disagreed as to the second sentence of subsection 1A of the statute. Is that an element or an affirmative defense? Defense counsel argued that is an element. The trial court disagreed and ruled that it's only an affirmative defense. We believe that is an element of the crime because it is in the exact same subsection of the statute as all the other elements. The state...
So what you're saying is that if you're holding back money because there's some dispute with a subcontractor or whoever it might be, that the state has to prove that. Is that what you're saying? Yes. Is an element of proof?
Yes, the state has to prove that there is no bona fide dispute.
In other words, there is no bona fide reason why the money is withheld.
Correct. The state...
Let me ask you this. How would they ever prove that? How could you ever prove that?
Okay. This case actually illustrates how the state could prove that. The state called the subcontractor and said, I was the subcontractor for the defendant. I did what I was supposed to do. But then he starts withholding money. He told me he withheld this money because of these back charges, but these back charges are frivolous. That was the state's evidence, and if the jury believed that, the jury could find that that met the element. Mr. COTTIER chose to take the stand to try to refute that.
So they'd have to do that for every single subcontractor that didn't get paid, I guess? That would be one way to do it?
Yes, Your Honor, unless that element was not in dispute, because as this court ruled in Gabriel, it is fundamental error to not instruct the jury on an essential element of the offense if that element is in dispute. But in this case, that element was in dispute, so whenever that element is in dispute, the state has to call the subcontractor and say, I was supposed to get paid this, I was not paid, there is no good reason to not pay me, I did everything right, there is no valid cause to withhold my payment. And then the defendant has the option of either taking the stand and saying, no, that's not true, you did this, I had every right to withhold payment. And then it's up to the jury whether the state met their burden of proof, whether the state is, and then make its verdict accordingly.
In this case, the defendant did take the stand, I take it, is that correct?
He did take the stand, Your Honor.
He said there was a dispute, correct?
Yes, he said there was a dispute.
Charges, leaks in roofs, things like that.
Yes, Your Honor. Yes, the defendant chose, and that is why it's so important to decide, is this an element or an affirmative defense? This is an element. That means the state has the initial burden of proof. The state has to show there
He
was...
probably wouldn't have testified then, you think? Maybe? Or, possibly?
Yeah, he may have chosen not to testify. He may have said, no, his testimony does not seem credible. I don't need to take the stand, refute it, and put my own credibility at stake. Or if he sees the subcontractor's testimony and says, oh, he does look credible, the jury might believe him, I'd better take the stand and testify to try to refute it. But that is why it is so important to find that this is an essential element, because it depends on who has that initial burden of proof. Does the state have to prove to prove there was no bona fide dispute, or thus giving the defendant the option to try to refute it? Or if it's an affirmative defense, then that means the burden's on the defendant. The defendant has to present some type of evidence which puts his credibility at issue. But if it's an essential element, which it is because it is in the exact same subsection as all the other elements, I cited the Mackey case in my reply brief as a counterexample, where I believe it was the third DCA looked at the carrying concealed firearm.
When he made his choice to testify, was he aware as to what the court was going to do vis-a-vis whether this was an element or a defense?
Let's see. At that part,
When the charge conference had been after he testified?
I believe it was.
Well, it usually is. I mean, was there something unique about here that was different? My point being is, eventually, though, wasn't the jury instructed that your client should be found not guilty if there was any reasonable doubt about whether your client withheld payment pursuant to a bona fide dispute? So, I mean, they were instructed on that, and they had the ability to use that information from the instruction. And if that's what they believe, to find him not guilty. So what's the angst between? I mean, I get the academic issue. What's the angst though from a pragmatic issue?
Well, the angst, as I noted in my reply brief, it has to deal with who has that initial burden of proof, and it also deals with how much evidence has to be presented.
Okay, go ahead. I'm sorry. Go ahead.
Your position is that the statute is ambiguous?
Let's see. Well, I believe that it is clear that this is an element because it is within everything, but if this is within the same subsection as the other elements, but if this court finds that it is ambiguous as an alternate argument, then I would invoke the rule of lenity. Rule of lenity, if it is ambiguous, we rule in the defendant's favor, and then if the legislator realizes, oh wow, this is an ambiguous, we don't think this should be an element, the legislator is free to change the statute and say, no, we meant this is an affirmative defense, not an element. We wrote it badly the first time around. We'll fix it the second time around. That's what happened in the Ciccone case that I mentioned in my initial brief, where the Supreme Court of Florida inferred that there was a knowledge element to possession of controlled substance charges. Then the legislator did not like that, so they said it is expressly, this is an affirmative defense. As the Supreme Court said, if this is meant to be a defense, the legislator can more clearly say so. And in this case, this particular statute, even if it is ambiguous, the legislator did not clearly say element or affirmative defense. Therefore,
Are there any other statutory constructions or canons that you wish the court to apply, or just that one?
just the rule of lenity, Your Honor, as well as also the plain text, which I believe the text is plain, that it's all in the same subsection. Subsection 1A has all the elements of the offense. If it was intended to be an affirmative defense, the legislator would have either used the phrase, it is a defense to this charge, or else included it in a different subsection, like the courts observed in the Mackey case.
Yeah. But it seems like, as Judge Lambert pointed out, that actually this did get into play. I mean, either as an affirmative defense or, the jury heard what his defense was. I was holding back money because there were a lot of problems. Evidently, they didn't believe that, and found him guilty. So, I mean, the issue itself, the factual issue itself, was in play in the case. And the jury was instructed in a way that they could have found him not guilty for, holding back money because there was a bona fide excuse, or dispute. So, so it is kind of an academic issue in a way. I see what you're saying. He may not have testified, but I don't think really we knew which way it was going to go at the time he did elect to testify. So, maybe, I don't know. I mean, it seems to me that he lost on the fact issue.
If I may, though, but then this goes back, though, to ultimately who has the burden of proof, as Judge Lambert said in the Gabriel case, and as the Supreme Court of Florida ruled as well. It's fundamental error to not instruct on an essential element of the offense, because that turns on who has the initial burden of proof. The state has to put on the proof, and the jury may well have said, I think the subcontractor is more credible than the defendant, but I don't think he's credible enough to get to proof beyond a reasonable doubt. If the burden of proof is on the defendant, by contrast, in an affirmative defense, he now has to establish his defense by preponderance of the evidence, which the state then overcomes.
It's like self-defense, yeah.
I wrote the Gabriel case?
Yes, I noticed that when I was preparing for oral argument yesterday, Your Honor.
He doesn't always get it right,
I don't know, or do I remember much of what I write?
Yeah, that's a surprise sometimes, when they come up with a case and you say, oh my God, it was my case.
Well, whatever I wrote was probably pretty good, so.
Yeah.
Yep, it was pretty good. That's why it's...
Oh, you think I should follow it today, too? Jeez. Yeah. Can't we just have Judge Jacobus rewrite the statute for the legislature and be done
That's
with
right, yeah.
But since this is back to my point, since this is an essential element of the offense...
The Gabriel case, what was the issue? What was the case about?
Let's say,
Help me out, what did it say?
I'm trying to recall what the jury instruction...
It wasn't the concealed weapon case, was it?
No, I believe it's...
Because that one, they changed it around, didn't they? That's the one, the legislature changed it?
Oh, let's see,
If you had
the
a
one the
permit or not a
it was
permit?
the possession was the one the legislator changed around, but then the legislator also did change around the concealed carry
Yep,
statute
concealed carry
where
is the
they...
one I'm thinking of, yeah.
Yeah, because they...
Whether
yeah,
it's an affirmative defense, I got a permit, yeah, I had the gun, but I got a permit.
Yeah, the
They-
third-
They made it an element of the proof, like you're saying here.
Right, they
Of course,
made...
that's a pretty easy one to prove, one way or the other.
Yeah, that is, they state simply call someone the Department of Agriculture to say, did you issue a concealed weapons license for him? Yes, I did. No, I did not.
Right.
But in this case, as I said before, the state can easily prove or attempt to prove that essential element. Just call a subcontractor and say, I did everything I was supposed to do. I was supposed to be paid. I was not paid. I cannot imagine any reason why he wouldn't pay me, or he gave me a bunch of flimsy excuses for not paying me. Those excuses are false. And then Mr. Cottier, he would have chosen to testify either way. He chose it, but then it's up to the jury.
Yeah.
But that's why it's important that this be an essential element, because the jury first has to look to the state's own evidence before considering the defendant's. The jury has to look at the state's evidence and says, does this all come up to proof beyond a reasonable doubt? And if the jury thinks it does come up to proof beyond a reasonable doubt, then they can look at the defendant's case and says, does this undermine the state's case? Does it weaken it to beyond a reasonable doubt or not? And then go back to see if the state's rebuttal buffered it back up. But instead, the court ruled that it was an affirmative defense, so they then looked at the state's evidence only as to those three elements that were in the jury obstruction. Then they looked at his case and said they either thought, no, his affirmative defense, he didn't even meet that, or even if he met his burden, the state overcame it on rebuttal. So that's why it's important that this be an essential element. And another reason I believe that this is an essential element is because that sentence helps describe what actually is a misapplication. The Weber case described obvious instances of not misapplication. The contractor ran out of money, there was a budget shortfall, but there might be instances where there is no budget shortfall, there's money to pay the subcontractor, but if he's not paying, what is a misapplication? It's not a misapplication if he had an honest reason for withholding the money, or he thinks he has an honest reason to withhold the money. One of the things the Weber court was concerned about was that contractors might be prosecuted because they genuinely think they can withhold the money.
It's a tough issue. Let me ask you a little, did he completed like 200 roofs, didn't he?
Yeah, the defense counsel made the proffer that there were 300. The witnesses themselves didn't testify to an exact number. That was something the trial court
A bunch
noted.
got done. How many didn't, like 50 or something, was it, that didn't get done?
Yeah, one witness testified to 50. By my count, there were 48 witnesses who came and testified.
Well-
I paid but didn't get a roof, and then the other about 12.
Didn't get anything done. I mean, it wasn't like they said I was almost done and then he
Yeah,
just
they
ran out
didn't
of
get
money.
any roof.
I mean, they paid money, he kept the money, he went to the Super Bowl, he bought a boat, he took close to $1 million.
They did the dock.
And these people are saying, but I gave you money and you haven't even started and done nothing on my roof.
They pitched
This-
shingles.
This kind of smells bad, like maybe you're stealing my money here.
Yeah, this
And
is-
isn't that something that the jury could have kind of weighed in on? And
Well, that
I do remember the Gabriel case now, go ahead, just for the record. Yeah, I remember.
Yeah, that's getting now into count one, but of course the jury could consider all the evidence in deciding all the counts. And I won't dispute Mr. Cottier is a bad businessman, to be sure. It's certainly not a good idea to spend money frivolously and not set aside money to do what you agreed to do. But that's not inconsistent with the theory that he was a bad businessman, which is why I argued for judgment of acquittal on the grand theft in count one, because there was some minuscule performance. It wasn't much, but there was some on a few customers, and then the other customers, not mentioned in the information, got their roofs. But then back to the jury instruction issue, that ultimately boils down to, is it an element or an affirmative defense? That depends on who does the jury have to look at first. Does the jury have to look at the state to meet its burden of proof, or they have to look at him to prove the affirmative defense? If the jury had been told this is an element of the crime, they might have looked at Mr. Sanger, the subcontractor, and said, we think he's credible, we think he's telling the truth, but we're not convinced beyond a reasonable doubt. We still have a little lingering doubt in our minds, so they might have voted not guilty. But instead they're told, oh no, that's an affirmative defense, so they're not looking at the state to prove lack of a bona fide dispute. They're just looking at the state to prove those first three elements. Then they look at Mr. Cottier's testimony in establishing the affirmative defense and said, we either don't think he's credible or we think Mr. Sanger is more credible. And that is why this court should find that it's an element of the offense, has to be reversed for new trial on those 12 charges. If the state legislature doesn't like that it was found to be an element, they are free to amend the statute, and I'm in my rebuttal time, so unless your
Okay.
honors have more questions.
Not right now, thank you.
Thank you.
May it please the court, counsel. Andrea Totten on behalf of the state of Florida. Your honors, I want to kind of start backwards because I think it's really important to point out at the outset that the jury was never instructed that withholding funds because of a bona fide money dispute was an affirmative defense. The jury was instructed, if you have a reasonable doubt about whether DUANE COTTIER withheld any payment in accordance with the terms of contract or pursuant to a bona fide dispute regarding the amount due, you should find him not guilty. So all this discussion about shifting the burden of proof was a discussion that occurred between the court and the prosecutor and defense counsel, but the only thing the jury was ever told in this case is the state has the burden beyond a reasonable doubt. If you have any reasonable doubt that there was a bona fide business dispute, you must find him not guilty. So as far as the jury is concerned, this discussion about who had the burden going forward
The
is...
state put on witnesses that, the subcontractors that said they weren't paid and there was no dispute about the money?
Yes, Your Honor.
Mr. Sanger was one, I guess. He was the big guy, wasn't he, or something?
Right, exactly, because my understanding is his company had the exclusive contract to do the roofing up until October 2015, when appellant stopped paying Mr. Sanger after having been slow with payments.
Certainly were issues with Mr. Sanger's roofing, evidently.
I'm sorry, Your Honor.
I think there were issues about his roof, some of his roofs. I mean, there were leaks, evidently, Thanksgiving, people got flooded.
That's what the defendant testified to. Mr. Sanger did not agree with the defendant's testimony
Mr.
about
Sanger
that.
testified first, I guess? Probably.
Correct. He testified in the state's main case, and then he was called again in
rebuttal?
rebuttal. Yes, exactly. But in the main case, he testified that his testimony was that there was no dispute, that the defendant just stopped paying him after slowing down with payments, then finally there was none. He was continuing to put on these roofs as he was obligated to do. Then there was, I believe, a dozen roofs that he actually completed, never received payment for from the appellant, and that's where he ended up putting liens on those houses, and those form the basis of all the misapplication of funds counts.
I'd like to go back to the instructions in the statute for a moment, because that's how you started out. I've got both of the instructions in front of me, and the instruction that the defense wished was to put item 4 into the instructions in addition to the 3 that you've listed. The instruction that was given did say if you have a reasonable doubt as to whether DUANE Michael Cottier withheld any payment, et cetera, it has that underneath of it. That was not part of the instruction, or that was part of the instruction?
The instruction, Your Honor, says if you have a reasonable doubt about whether Mr. Cottier withheld payment pursuant to a bona fide dispute, you should find him not guilty. And then there's a paragraph following that saying, if you find that the state proved beyond a reasonable doubt that the defendant did not withhold any payment pursuant to a bona fide dispute, then you should find him guilty. If you found
I wanted to make sure we were on the same paragraph, which is why I only read part of it.
Yes, yeah, so it has both sides of it. If you have a reasonable doubt, find him not guilty. If you do not have a reasonable doubt, find him guilty.
So tell me your position on the interpretation of the statute in opposition to what appellant has stated with regard to how that tracks the statute and why you believe that's the proper application.
Yes, thank you, Your Honor. First of all, I understand that opposing counsel is saying it's very clear, it's obviously an affirmative defense, and I'm standing here saying it's very clear, it's obviously not an affirmative defense, but I would point out the language that we're talking about here. Again, it is all under subsection 1A of 713.345, but this second sentence that's allegedly an element of the crime starts out, this paragraph does not prevent any person from, and that's where we get the bona fide withholding funds pursuant to a bona fide dispute. That simply does not read like an element. You've got the elements in the first sentence, and then to be clear, we would not, the legislator would not say that someone is guilty if these other circumstances, in this case allegedly a bona fide dispute, exist. That simply does not read like an element of the crime. And the fact that it's all in one subsection, I don't think is determinative here at all. To respond to appellant's argument in his reply brief in here today with regards to the Mackey case, for example, carrying concealed firearm, yes, there was discussion there that it made it clear, or more clear at the time, that having a license was an affirmative defense because it was in a subsection that was a separate subsection. That's something the court looked at. But there are examples of other statutes where not only is the affirmative defense contained in the same subsection, it's contained in the same sentence. For example, the burglary statute, all in the same sentence, says you can't enter or remain, and the second part of the same sentence is unless the premises are open at the time to the public or you're licensed or invited to remain. That is an affirmative defense that not only is not in a separate subsection, it's in the very same sentence as the elements of the crime. Another example would be the defense of having a valid prescription when it comes to possession of controlled substances. Again, the unless you have a valid prescription. It's contained in the very same sentence. So I understand that whether something is contained in a separate subsection is a factor that the court can consider, whether determining whether something's an affirmative defense or an element, but we can see that that's not always the case. And I just don't think it can reasonably be construed that way here. As was discussed a little bit with opposing counsel, it was clear right from the beginning of this case what the defendant's defense was, that he was asserting that there was a bona fide business dispute. It came up in opening, it came up in cross-examination, the defendant then testified, it was highlighted in closing, the jury is instructed about bona fide business disputes, told if you have any doubt that there is one that exists, find him not guilty. So the cases that appellant cites for fundamental error, for example, just don't apply here. Reed is one that was cited where the jury was given the wrong definition for malice in a child abuse case. And in that case, it was really important whether it was the legal malice definition or actual malice. So the jury just got a completely incorrect instruction. Delva, there was an element completely left off about the knowledge of the illicit nature of the substance in that case. Here, there's no missing element. Surely it's true that it wasn't listed neatly as element 4 right under number 3, but within the very same instruction, the jury is told about bona fide business disputes and what their burden or what their duty is if they have a reasonable doubt as to that. So the fundamental error cases cited simply don't apply here. The state's position is this is harmless error, if error at all. And again, we don't believe that it is an error. I think that the plain language of the statute indicates that that second sentence is an affirmative defense. But even if this court had some questions about whether that appropriately should be listed as an affirmative defense or an element of the crime, there's simply no error under the facts of this particular case because the jury heard all of the evidence, got the proper instruction ultimately, and was able to take that into consideration.
Ask you this, because the instruction that was actually given, reading it again, it says, it is a defense to the crime of misapplication of funds if the appellant withheld any payment, well, I don't know what you had it, but if the withheld any payment or any part of payment in accordance with the terms of the contract. In other words, it said that. It is a defense of the crime. What do you think that means?
Well, I see where you're going with that, Your Honor, but again, the jury is not being told and it's defendant's burden to prove that to you.
But I mean, it does say that. I mean, it's probably not really artfully drawn that way, but because it sounds like, well, it's a defense if you withhold the money for a bona fide excuse.
My argument would be that your average juror would read that to understand we shouldn't find him guilty if we believe that this is what happened. I think most people would see a defense as therefore not guilty, and then that's only buttressed by the fact that the very next paragraph is if you have any reasonable doubt.
Yeah, I see that too.
So I would still disagree with the assertion that the jury is thinking that the defendant has to prove anything in this case.
I mean, in this case, it seemed like that factual dispute certainly was in play, and they could have found him not guilty. I mean,
it certainly was. The jury heard thoroughly. I mean, as was referenced before, this was a lengthy trial with almost 50 victims and the subcontractor and people from the defendant's office. The defendant testified. There was no facts left out. There was nothing for the jury to be confused about. It came down to a credibility determination by the jury of whether they believed the state's witnesses, in this case because the defendant chose to make himself a witness, or whether they believed his version of events.
And Gabriel's different because in that case there was no instruction whatsoever about did the defendant know that was a police officer that.
I'm very familiar. I was the appellee in that one, Your Honor.
I
recall Gabriel. But you're right. That was this was post Ramroop in the
Yeah, and I
Florida
wrote
Supreme
Ramroop,
Court.
too.
And, yeah, and you got that one right, by the way.
I got the big part right. They didn't like the remedy apparently up in
I
Tallahassee,
still feel
but
that
I
you
got
got
the
it
big
right.
part
Don't
right.
beat yourself up. But Gabriel was fallout from Ramroop, and correctly, you're right, the jury was not instructed that they had to prove that, the state had to prove that the defendant knew that the law enforcement officer
And your
was a
argument
law
here
enforcement
is,
officer.
there was an instruction to the jury that said this is all, as using the vernacular from Judge Jacobus, this was all in play. They heard it, they understood it. That was pretty much the theme, I would, for lack of
Yes.
a better term, that, look, this is a business deal that went bad. I'm not a criminal. You know, things just sometimes happen to people in contractual relationships, and we'll sort it out in civil court, and I ought to be able to walk out of this courthouse.
Yes, that's exactly right, Your Honor. So again, I would say Gabriel is distinguishable because of that. We're talking about the instruction occurring further down in the same instruction as opposed to being left off altogether as in Gabriel. So if Your Honors do not have any other further
So
questions.
Judge Lambert, 1 out of 2 is not bad, really, you know?
Right.
Yeah.
Making a lot of money in baseball, in
I-
professional baseball, if I was at that rate, but
I was kind of on the wrong side
he
of it.
cut
but-
here. So.
Thank you, Your Honors.
All right, thank you, counsel.
Thank you.
Your Honors, opposing counsel. One thing I'd like to point out, though, the language in the jury instruction actually given that the state was relying on,
Yeah.
that similar language exists in the affirmative defense statute under self-defense. So that appears to be typical language. That doesn't change the fact that the jury was misinstructed. They were told that an element is really an affirmative defense. And as Your Honor correctly ruled in Gabriel, and as the Supreme Court of Florida said in Reed, if you don't instruct the jury on an essential element that is in dispute, it's fundamental error. Fundamental error is always harmful. Because fundamental error is always harmful, if this court agrees with my position that it is an essential element, then there is no harmless error.
Let me
It's
ask
a
you,
reversal.
what's your take, because the last part of the instruction says, if you find the state proved beyond a reasonable doubt, in other words, the state proved beyond a reasonable doubt, the defendant did not withhold payment or any part in accordance with, in other words, if you find the state proved beyond a reasonable doubt, the defendant, wasn't withholding money with a bona fide, dispute, it sounds like the burden's on them in that instruction.
That sounds, but as we discussed in the academics of it, but also as the practical matter, that depends on who has the initial burden. If it's an affirmative defense, then it starts on the defendant, shifts to the state, and
They
state
gotta
has to
prove it
disprove it.
beyond a reasonable doubt.
So what if the
Yes,
paragraphs are reversed?
Excuse me?
What if the paragraphs were reversed? What if the paragraph that was just read was in front of the one that says if you have a reasonable doubt as to whether DUANE Michael Cottier withheld payment? Would that make a difference in your argument?
I do not believe so. I believe that in that instance, the jury has to be told these are the elements the state has to prove, as in element 1, element 2, element 3, and then element 4. The jury was not ultimately told this is an element. That language was in there, but it was not listed as an element. Thus, the jury instruction was erroneous and should be reversed. Because as this court and the Florida Supreme Court ruled, if you don't instruct on an essential element, it is fundamental error. It is always harmful. We don't even get to harmless error in these types of cases. So that boils down to, ultimately, does this court think it's an essential element or an affirmative defense? I believe that from the plain text of the statute, it is an essential element. And even if the statute is ambiguous, invoke the rule of lenity and rule in Mr. Cottier's favor. If the state legislature disagrees, they can rewrite the statute to make it more clear, and we'll have that going forward. And I would also, just as a closing note, point out that I believe this is an issue that should be written on because the Florida Supreme Court's Jury Instructions Committee at least needs to be informed there is no jury instruction for this issue, so they can at the very least produce a standard jury instruction for future cases so we don't have this dispute again.
Gotcha.
And if there are no further questions, I will rest on my briefs.
Thank you.
Okay, thank you.
Very
Thank
good.
you.